All right, so I think we are probably good to go ahead and get started. I am going to go ahead and share my screen. Okay, so if you're not familiar with this already, my name is Amy Lee Hogan-Simonovich, and my co-host today is Karen Connolly. And we are attorneys at Ridge and Downs. Karen and I concentrate our practice in the area of workers' compensation litigation throughout the state of Illinois. Ridge and Downs also does other types of injury law as well as FELA, which is railroad injuries. So if anyone has any questions about any other type of injury law, feel free to throw those our way as well. But what we invited everyone here to join us to talk about today was the COVID-19 presumption. The legislature has prepared an amendment to the Illinois Occupational Disease Act. We expect that this will be signed into law by the governor shortly. So it's not official yet, but we want to be prepared for it and understand what is about to happen. The first thing that we're going to talk about today is, why is it important? Why would you want your COVID-19 condition to be considered work-related? And to understand that, you have to understand what your rights are under the Workers' Comp or Occupational Disease Act. So the first thing that you would get would be the right to payment for your medical treatment. So this is especially important if you end up hospitalized for COVID. You have a lot of medical bills that need to be taken care of. The second thing would be payment of your benefits while you are off work fighting this condition. And for our firefighter and EMS personnel, this also coincides with what your benefits are under PETA, the Public Employee Disability Act, and allows you to make sure that you're able to stay on salary like nothing ever happened and get your pension contributions, your healthcare contributions, all of that good stuff. So very important to make sure that you're able to get that as well when you're off work. And finally, there is the right to permanent partial disability benefits, and this is basically meant to compensate you for any residual damage to your body as a result of this disease. And you know, the science is still evolving on this right now. We're not entirely sure we have the clear picture on what all of the permanent implications of COVID-19 are going to be, and it's different for everybody depending on how the recovery and disease process went. So just making sure that, you know, any issues that you have going forward as a result of this are also taken care of. So Karen, would you give us a little refresher on the Work Comp and Occupational Disease Act, please?
Of course. In order to have a case under the Workers' Compensation or Occupational Disease Act, you first of all have to prove that there was an accident. The incident must arise out of it in the course of your employment, and it really needs to be connected to a risk associated with your employment. You have to prove that there's a causal connection between that accident and the injury that you've suffered, or the need for the medical treatment and the lost time benefits. And then lastly, you also have to prove that there is actually a permanent injury and or that you've lost time from work as a result of that accident.
So what
No, go ahead.
So what the legislature has drawn up is a procedure whereby if first responders and frontline workers contract COVID-19, there is a rebuttable presumption that the disease is related to their employment. The presumption applies to both the accidental exposure and the causal relationship between the exposure and the employment. Now, I'm sure many of you are thinking that is a lot of legalese. What the heck does that mean? So Karen is going to explain to us what a rebuttable presumption is.
A rebuttable presumption is very easy to understand. All it is it's an assumption of fact accepted by the court until disproved. What that means is that they are assuming that the COVID exposure is causally related to the employment if you fall into certain categories. However, the employer is allowed to come back and disprove that assumption. It is not anyone who has COVID is covered under the Occupational Disease Act. It's really important to know that, because some people will hear that and assume that that's all they need to do is say, I'm a firefighter, I'm a police officer, I am exposed at work because I work in a hospital. That's not correct. It is, however, very, very important, because it's a huge hand up, it's a huge help in order to prove how someone contracted COVID, where they were exposed to it, because those things are very, very difficult to prove in a court of law. So it is, we're very happy that it passed, but we have to understand what it is and how to use it correctly.
Okay, so there are certain categories of workers that fall under the presumption, and there's two basic categories. The first being what is considered first responders to the COVID pandemic, and that is police, fire personnel, emergency medical technicians, paramedics, all individuals employed and considered first responders, all workers for healthcare providers, including nursing homes, rehab facilities, and home health care workers, as well as correctional officers. The second category is what's called frontline workers. This is defined under Governor Pritzker's executive order from March 20th of 2020. This is obviously a very broad category. You've got human services, you've got essential infrastructure workers, essential government workers, grocery stores, pharmacies, pet supplies. I mean, it's extremely, extremely broad. So what's important to remember is that it is narrowed down in two ways. You have to be required by your employment to encounter members of the general public, or you're required to work in an employment location of more than 15 employees. Oops, I went one too far. Okay, so there's three basic ways that an employer can rebut this presumption. The first is by showing that the employee was working at home or on leave from employment for a period of 14 days immediately prior to the injury exposure. In other words, you're looking at whether you went to work within the 14 days prior to the condition. The second way we can rebut the presumption is the employer was engaging in and applying to the fullest extent possible or enforcing to the best of its ability industry-specific workplace sanitation, social distancing, and health and safety practices based on CDC, Illinois Department of Public Health guidelines for at least 14 days prior to the injury or exposure. Now, that is a really complicated way of saying, were they providing a safe work environment? Now, what's really important to note about this particular one is that it is going to be very dependent on when your condition comes about, because the best practice guidelines have changed over time as this pandemic has been developing. So depending on when your condition came about, we would have to see what the guidelines were at that particular time.
And I would make a note also that they're industry specific. So the guidelines that apply to a firefighter are not the same guidelines that apply to a truck driver, are not the same guidelines that apply to someone who works in a hospital. So it's really important, if an employer is using that as a defense, that we be able to go back and to look to make sure that they were actually doing that for those 14 days, because frankly, they probably weren't.
So the third way that an employer can rebut this presumption is by showing that you were exposed to COVID-19 by another source. You know, that you went out to a party, that maybe your spouse or your partner was sick first, so they maybe were the one that brought it home, maybe some travel plans that you had. And I know a lot of people think, well, you know, how would they know this? Trust me, between social media and a lot of our clientele is kind of small town Illinois, everybody knows everybody's business, and you'd be surprised about how much they know about what your goings on have been. Karen?
There are several rules that this amendment has established in order to support that you fit into that rebuttable presumption. First of all, they set a time frame. The COVID has to be contracted between March 9th of 2020 and December 31st of 2020. And they've also set out how the diagnosis must come about. If you're diagnosed before June 15th of 2020, that diagnosis can be confirmed by a medical professional or a positive laboratory test or antibody test. If it's after June 15th, you have to show a positive laboratory test or antibody test. The reason that there's that difference is that during the early part of the pandemic, there was a lack of testing ability. So many people were confirmed by a doctor's diagnosis. The amendment is not counting those people out. They're allowing those people to recover and to be part of the presumption. However, after June 15th, there's an understanding that there will be appropriate testing available to those people showing symptoms. So people should be able to be tested. It's also very, very important to remember that the people that do not fall into this rebuttable presumption, that are not covered in those categories, or if the presumption is rebutted by the employer, you still can succeed in proving a case under either the Workers' Compensation Act or the Occupational Disease Act. There's nothing precluding people who don't fall into that category from going ahead. There's nothing that precludes them from succeeding. It's just that if you fall into the area where the presumption applies, it's much easier to prove the relationship.
So in order to prove a case, there's a few things, you know, that we always tell people to make sure they're keeping documentation of. The first is, it is helpful to be able to prove work-related exposure, and even if we're operating under the presumption. So that especially in regards to the fire service, we're talking about any documentation of calls that you've been on. You know, you've been on a call where somebody had COVID symptoms, they were having trouble breathing, or you've later, you know, been notified that an individual you were in contact with tested positive to COVID. That information is going to be very important to us in proving the case. And so throughout this pandemic, it's highly recommended that you do keep track of those calls that you're on, so that we're able to have that should you get sick. It's a lot more difficult to, you know, go back and find it after you've gotten sick. So I know a lot of people don't like to prepare for the worst, but in these situations with what we have going on, it would be a good idea, you know, to keep that information and have it in case you do get sick.
Amy Lee, I'm going to interrupt you for a minute for two things. First of all, I have another example that I'm going to give. It is not fire related, but I spoke with someone who works for the city of Chicago in their fleet management. And there were some memos that were going around the various departments saying, if you work in this location, we've had 3 people that are positive. You know, wash everything really carefully. If you work in this location, we have 10 people. So those kind of memos are really helpful. But the second point is, I have a good question. Janet is asking, do I have to go to a doctor in order to get tested?
Did you want me to answer the question?
Yes, please.
There are testing options available in much more broadly in the community right now. You do not have to get the test through your doctor. There's a lot of clinics set up for, drive-through testing and other opportunities in your local community. So it's very dependent on where you live in the state of Illinois right now. If anyone is concerned about where to get a test in their community, I'd be happy to help them find those resources. Me personally, I'm in DuPage County, and we have a couple county-wide initiatives out here to make testing more available for people. I do believe right now for the antibody test, I know like Quest Labs is doing them, but you have to have a doctor's order for it. So I think it just really depends on where you're going and kind of what lab you want to go to. But if anyone has any questions about that, I'd be happy to find some resources for them.
And I would add too that it may not have to be your doctor, but it does have to be a doctor, a medical licensed professional. Like, don't go to your chiropractor and have him say, yes, I think you have COVID. That's not going to work before the Workers' Compensation Commission.
Very true. The other documentation that you need in addition to your medical diagnosis or testing results is going to be a note from your doctor to support your being off work for this condition. This is what is going to get you paid for that time off. The doctor has to restrict you from working for a certain period of time, and for you to be able to get your PETA benefits. And finally, if this category is the proof of permanent disability, if any. And as we talked about before, this is with regards to kind of that residual damage, how your recovery is going to look, whether you're going to have any long-term health impacts. So, if your recovery, progresses well, you go back to work and you're out on a fire call and you have shortness of breath, you're having trouble with your oxygen, we're going to want you to go back to, the doctor and document that you're having these ongoing issues, so that we can show kind of what your residual symptoms are and make sure that that is considered for your future.
And it's very unclear now what the permanent residual disability can be. People have not been recovered long enough in order to really understand what the long-term effects of a diagnosis are. They can be physical, they can be respiratory. I have a client right now that had, he was intubated for about 3 weeks and was in a medically induced coma. He has a great deal of difficulty using his arm. I'm not really sure why exactly, but it's because it has something to do with either the induced coma or some type of a nerve damage from that. So there's a whole lot of different things that can come about. So if someone does have it, don't think, oh, well, that's not what I read is the result in the newspaper. Talk to your doctor, make sure it's documented, even if it's something that's unusual or you might not normally think is related to that type of an injury, because it very likely could be, and that could affect the type of permanent disability you may be entitled to.
Okay, so that covers our brief overview of the COVID presumption. I have up on the screen our contact information. If you guys have any other questions or need to get in touch with us, we have our website. We also have our Facebook page at Ridge Downs. We try to keep everyone up to date with any changes in the area of workers' compensation. If you go to our website, ridgedowns.com, there's also a spot to sign up for an e-newsletter that we send out. We usually send out no more than one a month, so you're not going to get your email box spammed from us. But if you have any additional questions or you want to talk to us further about any injury law questions, there's emails there for Karen and I, or you can give us a call. I'm going to go ahead and stop my screen share so that I can come back and answer any other questions that we have.
Yes, please ask us any questions you have. And if it's not about the COVID-19 presumption, please feel free to ask us any workers' compensation questions you may have, because we're here to help.
Mike, did you have anything else that you wanted to add with regards to COVID in the fire service?
Well, normally I would, but for some reason you seem to have everything pretty well covered. And it was informative because there was stuff in there that I didn't know. So it was nice to watch. Good job.
Thanks, Mike.
Oh, thank you.
I'm so glad we had something to say you didn't know, Mike. I thought you knew everything.
Alex is asking, is there any difference for a firefighter who has been on the job for less than 5 years? And my answer to that would be no, not for the COVID presumption. That I realize that the other firefighter presumption, the firefighter does have to be on the job for greater than 5 years, but that is not the case for this specific presumption.
Correct.
Oh, we have another, you got it?
So we have another question regarding evidence of exposure. Should we what kind of evidence of exposure should we focus on trying to gather? And what kind of evidence will they try to use against us? So we covered this a little bit, but that is basically with regards to any documentation of people that you've been in contact with that have had COVID. So Karen mentioned interoffice memos. A lot of times you'll see a memo go out if one of your coworkers has been diagnosed with COVID to let you know that you have been in contact with a positive coworker, especially with regards to this session in the fire service. We're looking at calls that you've been on where someone is either COVID positive or showing COVID symptoms that you would want to keep track of. Information they're going to use against you. One of the most common things I think you would see is social media. Facebook posts, Instagram posts of you at a barbecue on the weekend, something like that, to show that you've been, out doing other things in the general public, and that you could have been exposed there instead of at work. If you're somebody who's going to work, coming home, going to work, coming home, you're not participating in a lot of extracurriculars, you'll have a lot easier time. If you are at barbecues every weekend or pool parties or, take a week in Florida kind of thing, you're going to have a harder time because that information is readily available. And most likely they'll find a way to figure that out. Everybody talks in a firehouse, especially lots of gossip. So I think that it's mostly social media and word of mouth.
And I would note too that there is, I know in my community, they are making households that have COVID-19 in them, that information, not the people's particular names, but the number of households and the address available to the police and fire services. And I realize that it's not just my community. I have a little community, but I realize it's not just my community. So, being able to show that we know that at a particular time, in this week, I started feeling symptoms on Tuesday. I went to the doctor on Wednesday and was diagnosed. In the week before, there were 14 households in my community that, had this, and we went on all these calls. That type of evidence is very helpful. You don't have to say, I think it was, John Smith at this address. You just have to show that it's more prevalent, or it's helpful to show that it's more prevalent.
Okay, any other questions? Will we continue to do webinars? Yeah, we are hosting this one 2 more times today. And then we will be posting it. So if you found this information useful, I'm going to be emailing all participants a link to the recording. So if you want to share this with any of your fellow coworkers, union members, friends, and family, please do. We're also available to do a private, viewing or Q&A session for your particular group or local. So if you're interested in scheduling something like this, if you have any virtual union meetings coming up, we'd be happy to talk about the COVID presumption or workers' compensation in general. You can just reach out to us and let us know. So if there's no other questions, I was trying to keep it at a half hour. We're just about there. So Karen, do you have anything to add before we sign off?
I don't. I would just thank you all for coming and joining us, and we really appreciate your interest.
Thanks, everybody. I'm going to go ahead and end the meeting now. Bye-bye.
Bye-bye.